Good afternoon, everyone. Welcome. The June 17th meeting of the Baltimore County Planning Board is called to order. I'm Scott Halupka, Chair of the Board. We will now start the meeting with a roll call to account for the members of the board present. When you hear your name, please say aye and remember to unmute and then remute your speaker. Mr. Array?
Aye.
Mr. Brady?
Aye.
Ms. Brophy is out. Mr. Duval?
Aye.
Ms. German?
Aye.
Mr. Heckman?
Aye.
Mr. Heinel?
Aye.
Mr. Hinton?
Aye.
Mr. Johnson is out. Miss Lilly?
Aye.
Miss Muneses?
Aye.
Miss Pinero?
Aye.
Mr. Schulman?
Aye.
And Mr. Tennant is out. Thank you. Will you now all please join me in reciting the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Again, board members, please remember to unmute your microphone when you are speaking and mute it when you are finished. Ms. Bensley, are there any changes to the tentative agenda as published?
No changes.
Thank you. In the June 10th email, you received draft minutes from the June 5th meeting. Hopefully everyone has had an opportunity to review the draft minutes. Are there any corrections or additions to those minutes? Not hearing any, I will entertain a motion to accept the minutes as circulated.
So moved.
Second.
All those in favor of accepting the minutes say aye.
Aye.
Opposed? Motion carries. First item on our agenda, we have a presentation from Mr. Andrew Brown regarding the Cycle 43 Water Supply and Sewerage Master Plan. Following Mr. Brown's presentation, board members will have the opportunity to ask questions. Then I will call for a motion to schedule a public hearing on the matter. Mr. Brown.
Thank you very much. Good afternoon. My name is Andrew Brown. I'm a civil engineer and project manager with the Department of Public Works and Transportation. I'm here to introduce the annual water supply and sewerage plan amendments for Cycle 43. I'm going to start with a brief refresher on the amendment cycle process. The April 11th, 1990 executive order specifies the annual process for petitioners to request amendments to the water supply and sewerage plan. The process begins in May with a deadline for submitting petitions, proceeds with public notice. We write a staff report, and then the staff report on the petitions is presented to the planning board, which takes us to where we are today. After introduction, a public hearing is typically scheduled for July. Once the planning board votes in September, the report will be circulated to the county executive and then be introduced to the county council. Once a council signed resolution is issued, that will be distributed to the Maryland Department of the Environment and the Maryland Department of Planning for a final review. The process typically concludes just before the next begins with the issuance of a final action letter and a notification of final action to the petitioners. So this year for Cycle 43, we received 3 petitions shown on the public notice there on screen. This public notice was posted around the county office building, in the Baltimore Sun and the Daily Record, and was included in a press release, all in compliance with the 1990 executive order. So before I give a brief overview of the petitions, here is the list of definitions for all of the water and sewerage map designations. These definitions are also included in the submitted staff report on page 8 for your reference. This year's petitions involve designations 1, 3, 6, and 7. With that said, let's hop into the petitions we received this year for Cycle 43. First, our petition, for our first petition, you'll see an aerial image here on screen of the property located at 3117 Rice's Lane, which is the subject of amendment petition number 25-01. The property is located south of the intersection of Windsor Mill Road and Rice's Lane in Windsor Mill, Maryland. The property is currently used as an Islamic center, and the facilities are on private well and septic. The petitioner is proposing a water and sewer connection to the existing mains located in Windsor Mill Road, adjacent to the property. One other consideration of note is that there is an existing sewer pump station on the other side of Windsor Mill Road near the property. Here on screen, you'll see two maps showing the water and sewer designations for 3117 Rice's Lane. The majority of the property is outside of the urban-rural demarcation line, with the exception of a small sliver along Windsor Mill Road. The entire property is within the Metropolitan District, and the current water and sewer designations are W7 and S7. That's no planned service. The petitioner is requesting that the water designation be changed to W6, area of future consideration, and the sewer designation be changed to S1, existing service area. The second petition, number 25-02, is for the property located at 3499 Sweet Air Road, which should be coming up on screen shortly. No worries. The property is located south of the intersection of Sweet Air Road and Jarrettsville Pike in Jacksonville, Maryland. The property is currently used as a commercial shopping center, hosting a variety of businesses such as a grocery store, pharmacy, food services, bank, office space, and other businesses. But the facilities located on the property are served by private on-site sewage disposal systems and a combination of on-site and off-site wells. Limited well yield has resulted in the importing of trucked water to supply the facility. Due to ongoing water supply issues, the petitioner is requesting a water designation change to authorize access to public water service. The property is located outside of the urban-rural demarcation line and is outside of the Metropolitan District. The current water and sewage map designations are W7 and S7, no planned service. The petitioner is requesting that water designation be changed to W3, capital facilities area. And for our third and final petition, number 25-03, for the property located at 8400 Park Heights Avenue. The property is located between Park Heights Avenue and Green Tree Road in Pikesville, Maryland. The property is currently used as a private men's school for grades 9 and above, and the facilities on the property are already served by public water from Green Tree Road and the on-site private septic system. Petitioner is proposing a sewer connection to existing mains west of the property at either Clifton Court or Green Tree Road. Both connections would likely require the use of pumping. Property is located outside of the urban-rural demarcation line and is within the Metropolitan District. Current water and sewage map designations are also W7 and S7. The petitioner is requesting the water designation be changed to W1, existing service area, and that the sewer designation be changed to either S1 or S3. And so finally, recommendations for all three of these petitions from the Department of Public Works and Transportation, the Department of Planning, and the Department of Environmental Protection and Sustainability are all provided in the staff report that's been submitted to Planning Board. And in accordance with the April 11th, 1990 executive order, we request that the board hold an in-person public hearing on the Cycle 43 petitions on Thursday, July 17th, 2025 at 5 p.m. And that concludes my introduction to the amendment petitions and the staff report for Cycle 43. Thank you for your attention.
Thank you very much. At this time, do any board members have a question? Mr. Heinel?
Forgive me if it's listed in here somewhere. I have not had a chance to look at it, but how do we have any idea of what the cost is to the county if we were to decide to approve or recommend that these extensions of water and sewer water be made to any of these projects? What is the county cost for doing that for any one particular project?
Sure. So cost estimates for a possible connection are usually not in the scope of our evaluation. Sometimes it really depends on the property and what the petitioner is asking for. In some cases, they're just asking for permission to connect, and that will come at the cost of the developer to build the improvements required to make the connection. Other cases are a little bit maybe less common, where they're just looking for some kind of larger solution, which may or may not involve the Department of Public Works or a lot of public money. So at this early stage, it's not always necessarily clear. Sometimes petitioners will include some kind of cost estimate in their case for the change, but that's not always a de facto piece of the puzzle.
Sure. So I was assuming when you said there was a connection across Windsor Mill Road or something, that was kind of a nod to the fact that this one wasn't so complicated because something's not so far away, even though it's not actually there yet, versus something like Sweet Air, which I didn't get the gist that anything was nearby.
Right.
I could be wrong about that.
Right. No, that's correct. And that is touched on in our staff report as far as the criteria that we're looking at in our evaluation as to whether we're going to recommend the change or not. The proximity to existing sewer and water, for example, is a big deal to the Department of Public Works evaluation there.
Sure. Thank you.
Ms. Meneses?
Is the facility that's functioning as a boys' school, is that a boarding school or day?
I believe it's boarding. They do. I don't know that everyone stays on site, but they do have dormitory space for overnight guests.
Other questions? I guess I do have a couple. I want to see if I was reading the maps right.
Okay,
The first and third looked like they were right on the edge of the Erdel.
that's correct. Right on the very edge.
And so would be water, septic in relatively close proximity.
In both cases, yes.
Yeah.
They're-
The Sweet Air one, though, I mean, what would they be connecting to? I mean, that seems pretty far outside.
Yeah, we're talking miles away from any public water. My understanding, based on their petition, is basically that they've been having a lot of trouble with their well systems and getting public or any kind of water to the site, and so they're looking for some kind of public solution. They don't, in the petition, they don't make a specific ask as to what that should be or could be, but putting miles of new water main is not exactly what we had in mind.
And it's for the entire shopping center, correct?
That property encompasses that entire shopping center. Yes, it's like a strip mall and grocery store, several other.
There was an example.
Yes, that's
Sort of a failing shopping center at this point.
Yeah.
A lot has vacated, I feel like, in recent years, which is a big disappointment considering what the residents that are around it.
sure.
Yeah, I just wanted to clarify, 'cause just given the location, that seems so far outside. I mean, it's outside the Erdel, outside the Metropolitan Water District. That's why I was confused.
Yeah, your understanding is correct.
Okay, thank you. Any other questions? If there are no further questions, I will entertain a motion to set a public hearing.
Be it moved that an in-person public hearing be set for Thursday, July 17th, 2025 at 5 p.m. regarding the Cycle 43 water supply and sewerage master plan amendments.
Do I have a second? All those opposed, say aye. I'm sorry, all those, that's confusing. All those in favor, say aye.
Aye.
All those opposed, motion carries. Glad you guys were paying attention to what I was saying. Thank you, the motion carries. We will now hear a report from the June 12th, 2025 meeting of the Landmarks Preservation Committee.
Thank you, Mr. Chair. At their June 12, 2025 meeting, the Landmarks Preservation Commission voted to issue 9 certificates of appropriateness to the following properties: the Shea property located at 208 Melanchthon Avenue in Lutherville, the Ash Malzik property located at 201 Morris Avenue in Lutherville, the Beverly property located at 16202 Corbett Village Lane in Moncton, the Gutierrez Krecken property located at 3605 Fieldstone Road in Randallstown, the Alms House and Pest House, which is a Baltimore County property located at 9811 Van Buren Lane in Cockeysville, the Custis property located at 16223 Corbett Village Lane in Moncton, the Wheaton property located at 207 West Seminary Avenue in Lutherville, Overbrook Farms LLC property located at 13822 York Road in Sparks, and the Gladden property located at 508 Sudbrook Lane in Pikesville. And that concludes the report.
Thank you. Ms. Muneses, it sounds like you had a lot on your plate for your first meeting.
Yes, it was
I can
long.
imagine.
And I need to learn.
Yeah, oh, I get it. I understand. And again, thank you for taking my place on that commission. Ms. Bensley will now fill us in on legislation recently passed by the county council.
Thank you. Resolution 2525, review of PUD, the Bosley, a resolution of the Baltimore County Council to approve the review of a proposed planned unit development PUD in accordance with county law. The General German Age People's Home of Baltimore submitted an application for review and approval of a 4.5 acre site located at 400 Georgia Court in the Southland Hills area of the 5th Councilmanic District to be developed as a PUD known as the Bosley. The PUD area is zoned DR 5.5 and is located entirely within the Erdel. The site is currently improved with a large vacant building that was used for decades as a convalescent continuing care facility. The applicant proposes to redevelop the property into a modern, state-of-the-art senior living community. The proposed community will be a 2- and 3-story structure with approximately 103 total units of mixed size and units. Pursuant to Section 324242B6 1 of the Baltimore County Code, the applicant proposes an environmental benefit by achieving at least a silver rating according to the National Green Building Standards. Additionally, as encouraged by members of the community, the applicant proposes to maintain, to the extent possible, the lawn and green space facing Georgia Court and to provide community access to both interior meeting spaces and outdoor open space amenities. Resolution 2825, Oella Commercial Revitalization District, a resolution of the Baltimore County Council to establish the Oella Commercial Revitalization District. The county's Commercial Revitalization District program provides incentives to property owners and businesses in specified areas to improve the exterior of existing businesses and to develop and redevelop underused properties. Through the creation of the Oella Commercial Revitalization District, the County Council seeks to provide incentives to encourage the redevelopment and reinvestment of several properties in the area. The assistance to property owners and businesses in the area is needed to stimulate public and private investment and renewed interest from surrounding residents and other communities. The boundary of the district is shown in Exhibit A, and that concludes the report.
Thank you very much, Ms. Bensley. This is the conclusion of our agenda. A reminder that we will reconvene for a public hearing at 5 p.m. Do I have a motion to adjourn the board meeting?
Motion.
Second? All in favor? Said it right this time. Motion carries. Thank you.
First summer you're there, they let you out.
Good evening, everybody. Again, welcome to the Baltimore County Planning Board public hearing on the cycle zoning petition for reclassification. The public hearing is now called to order. I'm Scott Halupka, Chair of the Planning Board. We will start with a roll call to account for the members of the board present. When you hear your name, please say aye. Mr. Array.
Aye.
Mr. Brady.
Aye.
Ms. Brophy. Mr. Duval.
Aye.
Ms. German. Mr. Heckman.
Aye.
Mr. Heinel.
Aye.
Mr. Hinton.
Aye.
Mr. Johnson. Miss Lilly.
Aye.
Ms. Muneses.
Aye.
Ms. Pinero.
Aye.
Mr. Schulman.
Aye.
Mr. Tennant.
Aye.
Thank you. The cycle zoning petition for reclassification was introduced to the board at the June 5th, 2025 board meeting with a presentation from Ms. Amy Mante, Deputy Director from the Department of Planning. Tonight, Ms. Mante is here to further present the item to the board. Following her presentation, board members will have a chance to ask questions, and then we will hear from the petitioner's team. Following the petitioner's presentation, we will again take time for any questions before accepting public testimony on the matter. Now, please join me in welcoming Ms. Mante.
Good afternoon, Chair and members of the Planning Board. I'm Amy Mante, Deputy Director for the Department of Planning. On the agenda for consideration by the Planning Board is a cycle zoning request. This is the first such request in front of the board in over 15 years. Since it's been such a long time, and in order to give the board a little history and context on rezoning, I'm going to provide an overview of the different processes for changing zoning in Baltimore County. After that, I'll turn it over to Director Lafferty to review the petition for Cycle 1, 2025, which is located at Loch Raven Boulevard and Joppa Road. In Baltimore County, there are 4 processes for requesting rezoning, or as it's referred to as classification, sometimes in the code. These 4 processes are comprehensive zoning map process, zoning map corrections, out-of-cycle zoning, and cycle zoning. The comprehensive zoning map process, or CZMP, occurs every 4 years. Some members of the board may have had the opportunity to be part of the previous CZMP, so you may remember how the process works. Anyone can apply for a rezoning request on any property in the county. Issues may be a single property or may cover multiple properties and include hundreds of acres. CZMP occurs over 12 months and can be broken down into 4 phases. Phase 1, which is the period for filing requests for rezoning, which includes petitions by the Planning Board, County Council, and sometimes staff. Phase 2 includes a review of petitions by agencies and other county staff. Letters go out to impacted and adjacent properties, and signs are posted. Phase 3, this is when the Planning Board, if you guys were here last time, you remember, holds public hearings, one in each council district. The planning staff issues a recommendation. Planning board holds work sessions and issues their recommendation. And then finally, in phase 4, the county council holds public hearings, one in each council district. And it's this final phase that the county council makes a decision on each request and votes to enact the zoning changes. Since 2000, there have been 7 CZMP processes. You can see from the numbers listed on the slide, the number of rezoning requests vary each process, but have generally been trending downward since the early 2000s. This is the most heavily used of all the rezoning processes. Zoning map corrections are another way the zoning map may be changed. This is a process by which an applicant submits a request to the director of the Department of Planning stating that they believe the zoning map is incorrect due to a technical drafting error. The Department of Planning may also initiate a petition if it discovers a technical error in the map. These petitions must be based on the following reasons. Technical errors must have occurred after adoption of changes during CZMP, there was a change in zoning during drafting of the map that happened outside of a CZMP issue, or there was an error made by the petitioner, provided the error did not impact the intent of the county council to place zoning on a property. If the director does not determine that a technical error occurred, the petitioner is notified that the request will not move forward in this process. The petitioner may appeal this decision to the Board of Appeals. There have been 29 approved zoning and map corrections since 2000. 20 of those were technical errors identified by the department, and 9 were errors that were brought to the attention of the director from the public. 10 were also submitted at this time that did not move forward. Just to note, of the 9 approved issues filed by a public petitioner, those were generally related to errors in adopting the zoning map changes from previous CZMPs into the zoning map, such as council voted on BM, and then when the map came out, it showed BL. Once a map error has been identified, it moves through a simpler process than CZMP. The department works with the county's Office of Law to research and create a report. The site is posted, there's notification in the newspapers, and then there is the Board of Appeals hearing and decision. Out of cycle is a process for expediting rezoning requests. The planning board and county council must agree that it's in the public interest because of an emergency in order to shorten the schedule for the Board of Appeals public hearing and decision. Since 2000, there have only been 7 approved out-of-cycle zoning requests. All 7 of those came from public petitioners. There were only 3 that were denied or withdrawn. This brings us to cycle zoning. This is the process for the petition on the agenda today. Cycle zoning allows for rezoning during the years between CZMPs. Cycle zoning may occur twice a year. Board of Appeals makes the final decision, and only the property owner or the contract purchaser can file a petition. In the cycle zoning process, the Board of Appeals may only grant a change if the record shows that there has been either a substantial change in the neighborhood since the last CZMP or an error in the mapping. Since most of you are familiar with CZMP, I just wanted to point out a few things about cycle zoning versus CZMP. When it comes to the final decision, during CZMP, the county council makes the final decision and can place any zoning designation on any property. In cycle zoning, the Board of Appeals can only grant a change if there's been a substantial change in character in the neighborhood since the last CZMP or an error in mapping. And they're usually granting the change that's being requested by the petitioner. For limitations during CZMP, county council cannot impose limitations on the use of the property. Once the property is rezoned, the owner may use the land in any way permitted by the zone. In cycle zoning, the owner can request the same type of decision, or they can submit a documented site plan specifying the way in which the property will be used. Also note, if a zoning change request is approved by Board of Appeals, compliance with site plan is mandatory, even if the property later changes ownership. And if the planned use is not developed within 3 years, the zoning automatically reverts back to prior classification. As I mentioned before, cycle zoning takes place between CZMPs. The timelines for cycles 1 through 5, as outlined in the county code, are showed on the slide. As I noted earlier, we've received a petition for cycle 1, which began earlier this year in April. The cycle zoning process has 4 periods defined by the code. The applications are originally submitted to the Department of Permits, Approvals, and Inspections. They notify our department because of the involvement with the planning board in the process. Other agencies are given the opportunity to review the requests. During period 1, agencies provide comments back to PAI, who then sends those comments to us. Notice is also posted. By May 31st, the staff report is published, including the Department of Planning's recommendation on the request. During period 2, which is the period we're in now, the request is introduced at the Planning Board, and it's during this period that the Planning Board holds a public hearing. By July 30th, the Planning Board has to have voted on its recommendation and transmitted that to the Board of Appeals. During period 3, the Board of Appeals has received the Department and the Planning Board's reports. The Board has 15 days to schedule hearings and post notice of those. And then during period 4, Board of Appeals has to have held a hearing and make a decision by December 31st. Since 2000, there have been 4 approved cycle zoning positions, most recent in 2010. Also during this time period, there were 16 other petitions that were denied by the director or withdrawn by the petitioner. While I know this is a lot of information, hopefully it was enough to provide the board with a little background on all the rezoning processes in Baltimore County, as well as an understanding the cycle zoning process to help frame the presentation in the hearing today. I'll be happy to answer any questions about the process at the end, but at this point, I want to turn the presentation over to Director Lafferty to present the petition for Cycle 1, 2025.
Thank you, Ms. Mante.
Thank you. Thank you, Amy. Mr. Chairman, members of the Planning Board, good afternoon. As Amy stated, we are in period 2 of this cycle. And following the public hearing, the board will reconvene on July 17th to deliberate and submit a report then to the Board of Appeals. Therefore, the board, should you want to, has the opportunity to make any changes, additions, deletions from the report that's been presented to you by the Planning Department. Let me suggest to you that this matter before the Planning Board is significant and serious request, in part because we've recently gone through the comprehensive zoning map process on this, the land around this particular parcels that were not included, but it's an effort now to change the classification that were not addressed in the CZMP. The petitioner filed a petition for reclassification on February 28th, 2025, requesting a change in the current zoning from BL to BMCCC. In that petition, it stated that there's substantial change to the character of the neighborhood where the property is located, and or that there have been errors that justifies the reclassification of 3 areas of land that are shown. I'm sorry, if you'll go ahead and advance that. Keep going. Next, please. Yes. This is a map which has been submitted as part of the petitioner's request. It shows 3 different areas of this property, which they claim or contend should be reclassified. This is also shown on pages 5 and 6 of your report, as well as on this slide. The next slide then also shows the area in question. If you're not, you may be familiar with this area. The roadway at the top is Lock Raven Boulevard. The one to the right side is Joppa Road. This property lays between that intersection. We don't have a pointer, do we? That includes land that touches on Joppa Road and also on Lock Raven Boulevard. And in our report itself, as we've provided to you, and then we will to the Board of Appeals, there's a variety of information regarding this site. The maps show that the site and areas have sought to be reclassified. The zoning and uses of the adjacent properties, meets and bounds description. All of this is in the report that you were sent. Indication that the property is on public sewer and water. But you will also note that the intersection at Joppa and Lock Raven Boulevard is considered to be a failed intersection under our current basic services. However, it's also in a commercial revitalization district, a designation that was given by the county council. And because it's in a CRD, it's exempt from basic services for transportation, which means construction can go forward in and around that in that area of the CRD, actually in the district itself. You'll also see in the report an extensive zoning history. And the properties at question here have been included in multiple rezoning requests over the years. However, they were not included in the CZMP issue 6-004 that the County Council approved on August 5, 2024. Master Plan 2030 also identifies the properties as connected neighborhood, and Lock Raven area is considered to be a mobility node. Now you need to back up, Crystal. Yeah, stay there, please. The petitioner, according to the code, is required to explain the reasons why reclassification should be granted and to provide sufficient detail. Again, the petitioner suggests that there's substantial change in the character of the neighborhood where the property is located and or there has been an error. The petition must provide sufficient detail to properly inform the county authorities according to the code, which does include the planning board. The department found that other than the rezoning of the adjacent properties, the petitioners presented no evidence, information, or details in the petition to suggest that there have been any changes of nearby uses, there's been any new development, or any other activity that suggests there's been a change in the character of the neighborhood, whether the commercial area where this is located or the adjacent residential community. Furthermore, the code also states that for a period of 1 year after the council has approved the maps, the Board of Appeals cannot consider change in the character of the neighborhood. There is also no evidence that in the last classification, again in 2024, which in this case where the BL designation was retained, that there was an error. The petitioner says it was intended to be changed to BMCC, but as we'll discuss in a moment, this was not included in the actual CZMP petition. If you want to go ahead. So the petitioner at the time has claimed that there's a mapping error. And as you read our report, as you read Mr. Vittori's report on behalf of the petitioner, he really leans into the CZMP issue in the discussion. The petitioner during that cycle was represented by Mr. Vittori, and he filed that issue on October 4th, 2024. He submitted his application for zoning changes prior to his in-person appointment with the staff, as he's required to do. His information was submitted through a civic access document, which was then reduced to an application summary report, which is standard for all CZMP issues. At the time of his submission, he did not include all the parcels on the document that was submitted. The petitioner did not provide any maps, any surveys, any CAD drawings, or anything else to identify the properties. He relied upon the information that was submitted here. And you can see that, well, you probably can't read the actual paragraph, although that is in the petition that Mr. Vittori has submitted on behalf of his client. So as part of the business practice of in the CZMP, the staff reviewed the request with Mr. Vittori sitting in the room and then created maps that would reflect the petitioner's request. So in doing so, he's asked to affirm that accuracy of the material that he has then been submitting. He was asked to review them, and you could see, if you go back one more again, Crystal, for a moment, you can see that the application summary was signed by Mr. Vittori on behalf of the petitioner on October 4th. He was then presented with an existing zoning map, which, although not shown here, he also signed showing what the current zoning is on the property. A map of the requested map, which is shown there on the left, was then presented to him, and that itself was then signed as well, indicating the accuracy of the request that he had submitted. And then a location map is also given to the applicant for showing where the sign would be posted, giving public notice of the issue that's before, ultimately before the council and as well as the planning board. In each of these instances, by the business practice of the staff in the county, he signed on behalf of his client, acknowledging the accuracy of these maps. And one can see, and probably should have done an overlay of maps, my apology. The area that is shown with the arrow is the map that was subject to the CZMP issue. The property that is at issue today that has been part of this petition lies just below it. Maybe I'll come over here. So this property right here is part of the petition, which, as you can see, was not part of the CZMP issue. The other two slivers that were shown on the earlier map are not reflected here. They were later developed through a engineer's survey, a survey and engineer's drawing of the property to be included. So the petitioner says that there was an error, but according to the code, a reclassification cannot be based on economic considerations. In the petitioner's submission, talks about the limitation on the ability to use the property, as well as being seriously hindered. Both of them are assertions that there's been an economic impact, which again, the code says cannot be a basis for the reclassification. Nor is the failure of the council to consider property that is not shown on the map. The colored map on this slide as well is the approved zoning by Councilman Ertel. And as you can see, the outline of that parcel or of those properties is the very same as had been submitted by and requested by the petitioner. And this, therefore, the other parcel was not before Councilman Ertel for his consideration. And yes, it was an error, but it was an error made by the petitioner, who now wants relief. And I believe the department would assert that providing this relief, granting this reclassification, really is rewarding the petitioner for errors that they should not have made in the beginning. So the department's report and the recommendation is to deny the request for reclassification, and therefore to advise the Board of Appeals that the request for reclassification should be denied. And I request that the board concur. And Mr. Chairman, if you have any questions for me or for Ms. Mante, we can answer them now.
Thank you. Any questions to the two presentations? Mr. Heine?
Director Lafferty, has anyone, I'm not saying that it necessarily matters for our decision, but out of curiosity, has anyone asked Councilman Ertel how he feels about this particular deviation, whether he believes it to be material, this mistake?
I've not talked to Councilman Ertel about whether it was material. I talked with Councilman Ertel while the other matter was pending, when the petition first came in. So this is the second petition. There was a petition that claimed there's a technical drafting error. I denied that, and I think that's part of the petitioner's submission, as well as my letter back to Mr. Schmidt on behalf of the petitioner, again, explaining why we did not find evidence that there was an error, technical drafting error. During the course of that, and part of my investigation, I talked to Councilman Ertel. He did say he believed that all of the property owned by the same owner, and all this property is owned by the same party, had been included in the submission before the council when he reviewed it and then approved what he has done.
Mr. Lafferty, if there was an error by the petitioner, wouldn't that fall under zoning map corrections, not cycle zoning?
Possibly.
Okay, that's like the first thing I wrote down was error by petitioner, question mark, when Ms. Mante was discussing zoning map corrections. So I was curious as to why it wasn't included in that and why it's included in cycle zoning 1.
You probably should ask Mr. Vittori when he comes up as to how he chose his strategy to present this issue.
Any other questions? Mr. Tennant?
Mr. Lafferty, just to clarify, if there is a rezoning that happens, does that classify as a material change in the neighborhood, or does that not qualify as a material change?
The rezoning itself doesn't constitute a change, because if the developer, owner of the property, never moves forward with anything to change the nature of the use of that property. Now, if something had been built during the intervening time, possibly that could be considered a change, a material change.
Any other questions? Thank you,
Thank you.
Director Lafferty. We will now hear from the petitioner's representative, Mr. Vittori, from Smith, Gilday, and Schmidt.
Good evening, Mr. Chairman, members of the board. My name is Jason Vittori with Smith, Gilday, and Schmidt, and I represent the petitioner, the property owner. Quickly, I don't want to delve too much and answer all your questions because I have 10 minutes apparently, or 9 minutes and 48 seconds or something to that effect. So I'm happy to answer them at the end, but to let you know, we have never questioned that we didn't get the entire property in when we filed it. No one is contesting that. As far as how that comes to pass, if you work in the private sector like I do, and a client gives you an address, and you type in those addresses on my neighborhood, and those addresses are 1731 East Joppa Road, which is cited up there, 1703 East Joppa Road, and 8635 Lock Raven Boulevard, you get two pieces of property with their own tax ID parcels. There happens to be a third piece of property that was not included, which you saw outlined over there. So with that being excluded in the property lines and without an ALTA survey or a CAD file, the lines didn't perfectly match up. And what we're talking about, that little piece of a 1.7 some acre parcel, is approximately 10,000 square feet, or maybe a quarter acre of that. So at the end of the day, what we're trying to do is get the property, which this planning board reversed the planning department's recommendation during the 2024 CZMP on, saying we think this property should not be BL and BM like planning does. We think it should be BM CCC. So what we're asking you today is, can you make the entire property BM CCC like you thought during the 2024 CZMP? And then the councilman then incorporated that as part of, if you're to click on the public hearing on cycle zoning reclassification petition, yes, these are the comments from other agencies. You heard some conversation about this is a failing intersection. There's really nothing they can do to improve this intersection, with all due respect. I know I personally helped out an affordable housing project just across the street from the Belloc Diner and the Total Wine at the Days End that has been a blight on the community, and that got approved somehow. SHA, in their comments, they're the second one. The first one's DPWT, they're the ones in charge of traffic for the county, has no problem with this rezoning being granted. At the bottom in the highlight, that's SHA saying they have no objection to this. So from a traffic standpoint, that's completely irrelevant. What we're trying to do with the commercial revitalization district is to be able to build something. Keeping the zoning exactly the same, or having a sliver of this property that the councilman went out of his way to rezone and incorporate in the planning board, make a recommendation, makes no sense. As far as any kind of preconceived notions, 15 years ago was the last one of these reclass cases to get filed. There has not been another one done since, and whatever the rationale is for that is what it is. But in this case, you've got no case law cited by us, but I have read the case law, having practiced in this industry. Generally, we discourage our clients from utilizing this process, and they can use the CZMP. But waiting another 4 years doesn't seem like the most diligent use of anybody's time, that we're trying to encourage some kind of development. This is where it happens. If you scroll through this a little bit more, that is an email exchange I had with Jeff Perlow in the zoning office, who accepts this filing of this thing. And there's a lot of outdated stuff from 15 years ago that doesn't make sense. If we pay $15 for posting, I promise you, the only posting that happens is with the Board of Appeals, and it's more than $15 these days. If you keep going, we'll get to, this is the petition. Next, we get the actual justification I provided. If you keep going, sorry. That is a justification, 1 page, 2 page. This is my cover letter that I submitted, or under Larry Schmidt from my office's signature. And this right here, if we could zoom in on it, is an email as part of the correction of zoning map, because we submitted that. And there were initial discussions that Larry had. I wasn't privy to those conversations, so I'm not going to represent what transpired. But my understanding from Larry was those conversations with our planning director were positive that we were going to be able to utilize the correction of zoning map process. And this email dated November of 2024 indicates we pursued that before we filed in February the deadline to get in this cycle for this reclass. So we absolutely pursued that. My letter was, before that was my letter asking, or Larry's letter asking for the correction of zoning map. This is the email from Mike Hertel, because the standard for that correction of zoning map was very much, is just says, has there been a technical drafting error? There's no definition of technical drafting error, and it had to be by the petitioner. So we, the petitioner, said, yeah, we did make a technical drafting error. We left out a whole tax ID. If that means we got to wait 4 years, that's what it means. But I'm not aware of any case law or anything. There is an unreported decision about that. That matter has gone now because we've appealed the director's decision not to send it to the board, and the board's considering that appeal. If the board overturns the director, it'll go back to the director, who will then send it to the board for a substantive hearing about whether there in fact was a drafting error. And the second prong to that test is, was it the intent of the councilman? This email, that's, I think it's PDF 13 of 45 that you can see is on there, it clearly says it was my intent to rezone the entire property. It was his intent. Obviously, the planning board's made this finding in the past. The councilman said this. As far as what the basis is for correction of a zoning map, and frankly, I think the standard for this reclassification request was misstated. A change in the neighborhood, you can't tell me a change in the neighborhood is not the actual property you're on. It's usually a property next to you has been developed, has been rezoned. Something has happened in your neighborhood. In this case, the actual property has been rezoned all but 10,000 square feet or a quarter of an acre. So yes, there has been a change. There's a rezoning, but you're going to develop all but a little sliver of your property in an area where every square foot seems to make sense. That doesn't make any sense. I wholeheartedly disagree with that. I don't think the case law supports that. I don't know where that policy comes from, but it's bad policy if it's one that's just made up out of thin air. As far as what else is in here? And to give you the sense of, if you look at if you could scroll down, I'm going to guess it's probably PDF 30, maybe somewhere in there. I'm looking for the deed. The way you figure out what property, there it is. At the top of this deed, it says CNC title, file number, and then tax ID number. There's the tax ID number that got left out up there. If you're to scroll to the intake sheet at the bottom of this deed, the other two tax ID numbers. So if you're just looking at the intake sheet, those are where it is. We obviously missed out on the filing of this. I don't think there's anything that penalizes you in the standard that's stated in 32.3.510. Respectfully, if I think I heard Director Lafferty quote a section out of 32.3.510 saying within a year, you can't say there's been a change in the neighborhood if for the issue it's filed. If we didn't file this sliver of property we're trying to change, it's outside of what got rezoned. We're not saying that there was a change to the actual property. It's a property next door to it. And I think that is a distinction that needs to be pointed out. But certainly as far as whether it's a technical drafting error on the correction of zoning map process or it's an error insofar as what was rezoned, the whole point is when you file a CZMP issue, in an optimal world, our clients would all give us Alta surveys and these things. If a client comes to us and the deadline to file is tomorrow, you don't have time to get an Alta survey. So you get in what you can, and you theoretically, if you go back and work with the client, are going to get information, an Alta survey and this other stuff, and correct it by asking the planning staff, the planning board, or the council to then change it. And maybe they do, maybe they don't. But once that window of anybody putting an issue in is done, it's over and you're moving through it. So we're in an unfortunate circumstance here. There was nothing deviant. We weren't trying to trick anybody and have some element of the property not included or considered by the planning staff, the planning board. Everybody considers it, went through the process. It was, for all intents and purposes, approved. And then we realized after the Alta survey came back, hey, not all the property was rezoned. And the other two little slivers are just the difference between the county's GIS, which as part of the correction of zoning map matter that went to a hearing for the board and has the board's deliberation coming up on June 25th, which is 8 days from now. And then presumably we'll have maybe a decision out before the vote here on July 17th on this particular matter. And with that, I don't want to take all your time. If you got any questions.
Thank you. Any questions for Mr. Vittori?
Yes.
So during the CZMP process, when did you realize that the error was made?
After the CCMP process.
After the CZMP. So second question, what impact would this have if it is not approved now? If the change is not made, what impact would that have on your client?
In all likelihood, we'll be back in 3.5 years in front of you talking about rezoning this little sliver, and the property will sit there doing nothing.
So you're saying that right now you are ready to do some improvement in development?
I'm not personally. My understanding, I represent the property owner. The property owner has somebody interested in doing something.
Right now?
I think, yes, right now. I don't know what that is, but right now, something.
Mr. Heinel?
Thank you.
Sorry, my piggybacking on that, my question would have been, throughout the process, there would have been opportunities to make the correction. So you answered the question when you said, he asked you, when did you realize the mistake had been made? And you said after CZMP. I'm wondering why it wasn't discovered by the owner of the property prior and looking and saying, hey, look, there's this sliver that I own. But I understand you said you've answered the question. You realized it after the
I
fact.
think a lot of clients are pretty unsophisticated when it comes to my property's in. It's just, I'm good, as opposed to you need that part.
So sorry, follow up one more thing. Any of the neighbors objected to this, and this was part of their agreement to not object to your proposal to rezone this property? Because to me, that would be relevant to know, look, did we negotiate this? You're saying there's nothing deviant. I heard you say that. But is there a neighboring property who said, hey, look, I'm okay with what you're doing here as long as you leave this sliver the way it is. And now you're coming after the fact and saying, mistake. I'm taking you at your word that that is not what happened, that this was a mistake and that the councilman would have approved it anyway. And there's your answer. But if it was a negotiated for thing that was not included, I would say that's relevant to this discussion.
Yeah, there was no negotiation, and you can take me for my word. I did not intentionally do this because
I understand.
You're spending a lot of time.
It's a mistake. Yeah.
Energy.
Understood. Understood.
Mr. Braddock?
What is on the sliver of property now?
Excuse me?
What's the property being used for now? The slivers of property?
That image of it. It's retail space that's really not good retail space. Yeah, you can see, and I can point to these things as well.
Next to the car wash?
The car wash is down past, that's Yakima Road there. And there's a little gas station right there and convenience store, which in talking to the councilman was a lot of drug and bad criminal behavior goes on there. So something here would be nice to kind of get that. It's this little building is essentially what we're talking about. There's the two white buildings that have different heights to them. Then there's this additional white building, and that is basically the outline of what is the property, which has frontage on Joppa and frontage on Loch Raven, which I know you're not supposed to drive from Loch Raven through a parking lot to Joppa, but since there isn't really much of a merge lane there, I'm going to guess that some people in the public may actually do that, and it might make the traffic situation better.
Is it the white building in question, the second white building?
This white building is in the issue. I think the disputed part is the little sliver there, a little sliver somewhere else, and then it's this larger rectangular piece with the black roof. These other pieces, look, you're from the 1st District, Mr. Tennant, and Mr. Warren, I believe my recollection is when we were here for the CZMP asked, does the zoning line really go through the middle of the building? And I said, I guess so. Maybe don't own the other one. I honestly didn't know. But again, in response to Mr. Heinel's question, even if we figured out when we were in front of the planning board, it's too late to put the issue in for consideration. So had we responded to Mr. Warren back then, it wouldn't have made a difference because the window to include your property had closed.
I'm not sure who answers this question, if it's the planning board or you, Mr. Vittori, but does it matter to us if this is considered a cycle zoning issue or a zoning map corrections issue?
So
Is that of the four,
Yeah.
errors, I guess, or the four ways to, well, CZMP is not an error, but the four ways to rezone, does it matter which one it is
there's also a
classified
zoning
as?
text amendment of
Right.
some sort. There's also a planned unit development process you could utilize. They aren't technically changing the zoning. The four are correct. As far as the correction process that's laid out in 32.3.3, or whatever the section is, 302 or whatever it is, that process does not include the planning board. So you have no involvement. It began with a letter, and if we can go back to my thing in my letter to, or Mr. Schmidt's letter to Mr. Lafferty, it's probably exhibit 12 or 11 of 45. I know
It was an email, I think.
this is the letter that we sent formally requesting in 32.3, what is the 231A? It says we have to submit a letter. There were preliminary conversations before that, is my understanding. Again, I wasn't part of them. And then it culminated with a letter being filed, and that's November 12th. Like, the conversations may have been taking place for at least a month before that. It was shortly after the CZMP, it got figured out, and we began, what do we do about this? How do we fix this? This is a problem. So this letter went in, and then the councilman, right short after that, the next exhibit on November 25th, submitted his email stating his position in case it was clear that we had not summarized that it was his intent to rezone the property and it did not change his intent. He said as much. Again, not for the board's consideration, but relevant as far as yours. And then following that, we got a letter from Mr. Lafferty 2 months later on January 23rd denying it, indicating we could take an appeal. Thereafter, we took an appeal to the Board of Appeals. Board of Appeals scheduled it. Hearing took place. That hearing concluded. They asked for memorandums. Those memorandums are due this Friday. The 25th is the deliberation where they're going to consider our arguments made at that hearing by Mr. Schmidt and the memorandums being submitted. And then it'll go, as I said, back to the planning department if they overturn the director's determination of it shouldn't be a correction of zoning map. And then it'll actually go back to the Board of Appeals for them to consider the merits of it, which seems a little bit contrived, but that would be the process.
Mr. O'Reilly?
So you did receive a letter from MDOT, State Highway, right?
I'm not really certain. You're going to have to ask planning how they distributed things. But as part of this reclass process, when we file our petition, as we did back in February, they seek comment. It gets filed with the zoning review office that then gives it to planning. I don't know if zoning review or planning.
Okay, my question is, who obtained a letter from State Highway?
I don't believe it says SHA, no objection to
Approving?
approving 31025.
Okay,
Let's
so,
say who.
so who received that letter from State Highway?
I didn't send it to him, so is anybody that sent it to him? Whenever there's a development process, development committee, they wear hats. Whenever it's the zoning petition, it's a zoning advisory committee. They're just different people wearing different hats. So whoever is the designated person from SHA that receives it in the, I guess, district office, I don't know who that person is.
And they did indicate that there's no issue with that in terms of traffic, right? But you did mention the letter. I would assume that you have a copy of that.
This is all I have. This is, I don't even know. I didn't draft that. Somebody in the county did.
Chairman, if I may, if there are questions about this particular document, we have representatives from PAI here who can address that. So maybe Ms. Nash could come up whenever it's appropriate.
Do we have any more questions for Mr. Vittori?
I do. I just want to go back to something that I thought I heard you say, that Director Lafferty said you can't, within a year of CZMP, you can't use the substantial change in the character of the neighborhood as a reason. And you're disputing that?
I heard him say something to the effect, if you were to look at the Baltimore County Code, in particular, section 32-3-510, and subsection, I don't need my readers, but I'm going to squint, B, limitations on granting reclassification, subsection 1. except as provided in paragraph 2 of this subsection for a period of 1 year after an amendment of the zoning map has been adopted for the subject property, which means the actual property as opposed to what we left out of it, subject property by the county council, the Board of Appeals may not grant a zoning reclassification of the property on the grounds that the character of the neighborhood has changed. So again, I think that is a
Does the
situation.
subject property refer to the two properties that we looked at last year, or is it the subject property that's before us today?
I'm pretty certain what they mean is if you had a property and it's next door to it, you're next door to the property, you can't change the property that was rezoned. In this case, whatever was within issue 6-004 in the 2024 CCMP, which we're not contesting any of that rezoning to BMCCC because we wanted that. It's anything outside of that isn't prohibited. Anything within the four corners of issue 6-004, that I read that as being prohibited.
Okay.
Ultimately, the board is the one that makes this determination. You guys are making a recommendation. Determination.
Mr. Chair, I have the last question.
Well, we've got several others. So go ahead, Mr. Wright.
I apologize.
You've answered my
Okay, I'm going to go back to what Mr. Hino asked you earlier. Did you get support from the surrounding businesses and community?
While I don't have a letter, I will tell you I spoke to the community kind of behind where I said the gas station and the car wash is, and they did not say anything. They didn't follow up with me, really. I did follow up with them a number of times, and they said anything you can do to get rid of that gas station or do something that makes them go away because they're a blight on our community, we're in support of. That was the only conversation I had with anybody in the community.
You would think that you should get something in writing.
I don't think you need to. What you need is to convince the one person in the county due to this councilman of courtesy that has a vote, and that is Councilman Ertel, who again put an email out that he supported this property being rezoned. So he presumably had conversations with the community, weighed all the different factors, made a determination along with his colleagues on the council to rezone this property, albeit without the error that we committed getting the entire property.
Ms. Meneses?
My question was on the applicant summary report. Under justification, the last line says it's an ideal location for a full fuel service station. But you just said the
You're going to have to point me to where that says.
last line of the justification.
Oh, you're asking about, so we had requested, and if you could go to the, it's tying into a bunch of things, but I've got a lot of corrections on planning's report and things that I don't think are really that relevant, but when we were originally doing this, we were asking for the BMAS. The AS is Automotive Service District Overlay. We didn't get that. We got the BMCCC.
So you're no longer, your client is no longer planning on.
I don't know exactly. My client is not doing anything besides either leasing it or selling it. The particulars of that really aren't the issue here. We're not revisiting what the councilman decided at that time. The standard is, has there been a change or a mistake? I don't know. I mean, it's like asking someone's religion.
True,
on something.
but yeah, true. But you also said that if your request is denied for the rezoning, then this property will have to sit vacant or as is for the next 3 years until the next CZMP. My question is, like, if the plan originally was to build a fuel service station, is this 0.010 of an acre or whatever, is that really going to prevent your client from doing something?
43,560 square feet and 10,700 or whatever is a quarter of an acre. And a quarter of an acre is a pretty significant period of time. So as I understand it, with the people my client, the property owner, is talking to about potentially leasing or selling this to, it is very much a big deal. We're spending a lot of time and resources toward that end. So yeah, it's very much a big deal.
And just to clarify, so if you got everything you wanted, right, so the property that went through CZMP is now BMCCC, correct? It's not AS.
That is correct. BMCCC.
And if you were able to, the goal is to try and get this remaining sliver the same zoning as the other one?
The goal is to get the same zoning. That is very much the goal. As far as what you can do, that's not really the question you have to answer, or I have to answer per se. It's zone BMCCC without the exception order. The councilman intended the entire property to be rezoned BMCCC. Generally, you can pontificate what's in the report that's been pre-provided for you to then, I guess, forward to the Board of Appeals, who ultimately makes this decision, is going to hold an evidentiary hearing. One that will be advertised and placed signs on the property, whereas no signs were posted for this meeting. It merely in the code requires you to post notice in two newspaper publications, which was done. And as far as when this comes to hearing out there, if there's a use that's permitted by special exception, which other uses are, and somewhere in the report is, I don't know what it's called, a strip joint or whatever it is, some kind of something or other is one of these things you can do in downtown Towson. Nobody's applied for. You need a special exception. That's a whole zoning approval. There are uses that are permitted by right. There are uses permitted by special exception. There are uses that are prohibited. Whatever it is they do is either permitted by right, prohibited, or by special exception.
And just to be clear, because there's a lot of new members on the planning board, the planning board went against the planning department's recommendation on zoning for the site, correct?
That is correct.
Okay.
I don't have the statistics on the exact number of votes, if it was unanimous or what, but it was changing with the planning. If you could pull up, I think in the, yes, on this, probably about 35, somewhere down there.
We want the law.
That's it. A log of issues, yes. Thank you. Yeah, if you can read it, it's the top issue. I guess maybe one of, did I give you something that this image of 2016? It's just a question of being able to turn it around. Yeah, so it says 6004, 1.19 acres BL, 0.56 acres BM, existing zoning in acres. Requested zoning in acres, BMAS, 1.72 acres, PR 5.50, 0.02 for a total of 1.74. The numbers change from 1.75 to 1.74. Final staff recommendation, the same as the existing zoning in acres, BL 1.19 and BM 0.56. Planning board recommendation, BM CCC 1.72, PR 5.5, 0.02. And then the county council decision was to have the exact same numbers and acreage and zoning as what the planning board recommended. And then if you skip down to one page, we'll see that 6004, this past me, one more page, right? 6004 is one of the issues that Mike Bertel is in agreement with the planning board on.
Mr. Heckman?
Yeah, I'm trying to think back a year and a half ago, and I can't recall in those endless hours of meetings, hearings from the public, if there was anybody who spoke up for the originally.
The only thing I recall.
And what pushed us to change to BMCC. I mean,
Yeah,
it would be nice to know what happened back then, because I mean, I took a lot of notes, but I probably threw them all out.
You don't remember 600?
No, it was only 350 or something.
Mr. Luca, certainly after Mr. Vittori's responded to his questions, we're more than happy to answer any of the questions and probably can help on some of the CZNP matters as well.
Again, any other questions for Mr. Vittori? No, thank you. Appreciate it.
You want Ms. Nash to address the item?
Yeah, if you could, Mr. Array's question.
Good afternoon, Sally Nash, Department of Permits, Approvals, and Inspections. This is just our standard form that we use for our zoning advisory committee meetings. We send out a slate of agenda items to many different agencies, including State Highway. And this is typically how State Highway responds to us. They just handwrite
And just to clarify, this was in response to the CZMP request that,
To this.
it's to this one. Okay, thank you. Okay, thank you. Any other questions for Ms. Nash?
So I have one more question for you. Maybe for the director also, and Ms. Mante. What impact would it have on the county if this is approved as requested? If the change is made, what is there a detrimental effect to the county?
So keep in mind, this is intertwined with the other petition that has already gone to the Board of Appeals. And when Mr. Schmidt came in to talk with me about that matter, he indicated that they have a contract purchaser, which is Sheets, that would be looking to build a gas station on this site. I don't know, with convenience store, whatever else it is. And that the contract purchaser was looking for all the property owned by this single owner, the BMCCC. Actually, they petitioned initially to be BMAS, which is automotive service. By right, they could have built an automotive gas station. So the impact is that, at least according to what Mr. Schmidt shared, is that this contract probably would not go through with the zoning as it is there. So they're seeking, of course, to get the BMCCC, which would allow them to transfer all of the property owned by the single owner to a contract buyer of Sheets. Whether they could build it without the change of BL is another matter. And if I may, Mr. Heckman, your question about CZMP, there was testimony before the planning board at the 6th District public hearing in opposition to a gas station at this site. And so one of the reasons I believe that the planning board changed or recommended a change is that CCC will allow an automotive use, but only by special exception, which requires a public hearing. And in fact, Mr. Urtel told me that he was in agreement with that because he wanted the public to have an opportunity to weigh in.
That makes
whether
sense.
there should be a gas station.
That makes
Instead
sense.
of giving it as a matter of right. Which is why then he concurred with the planning board's recommendation. And again, the only property that Mr. Urtel, Councilman Urtel, was considering is what was in the lines. He may have known or may not have known who owned the other property, but he was, what he's told me, he was focused on what was before him.
Any additional questions for Director Lafferty? Mr. O'Reilly?
I'm sorry, today is my.
That's fine.
Mr. Vintori,
Yes.
is it true that the plan is to put a big gas station in that area,
Nothing's been filed yet.
but it's in discussion with your client?
I'm not aware of all the people they're talking to, but that's one of the people they're talking to. Again, the zoning is the first thing that we need. What we do after that, we'll see.
So that is why I said, Mr. Chair, I don't know whether we have to vote on this today. I don't know. So I would, it's good to be transparent with, with the neighbors in that area. Just my recommendation, just my personal view, to talk to the businesses there, be transparent with them and let them know what is intended, what the intended use will be now or moving forward, to seek their support. If there are any objections, we would like to know. You need to get support in writing from the neighbors. That is just my recommendation. It will make it easier. You have to let them know what is coming, because you have to be very open and transparent. Not you personally, but since you are the leader of the team. So.
Just to make clarification.
He went around.
EMAS and the BMCCC are both under section 405.2 to Section 405 of the zoning regulations deals with fuel service stations. And they enter no district overlay. All three of those are AS, some other district overlays. If under Section 405.2.B.1, if you're inside the URL, if you're in the CCC, AS, IN, or MD 43 districts, you need special exception approvals. There's no difference between AS or CCC, especially to that.
Mr. Tennant?
It's not permitted by regulation. It's not.
So just to confirm, the matter of the rezoning right now is not to determine the exact use. That'll come at the special exception when they actually have a hearing on the actual use. So at this point, we're not discussing what the use is. It's more about the zoning that you previously brought up in your email with Mr. Ortel, correct?
Yeah, I mean, there's specific findings that the board has to make. Respectfully, the planning board's duty is to issue a report. I mean, say you have to have an introduction, public hearing, and a vote in the actual code, because the council has the legislative authority in Baltimore County. When they wrote this law, that's what they said. They said, planning board issues a report. It goes to the board of appeals. Whether your report's a thumbs up, thumbs down, still goes to the board of appeals, and they make a determination. I just think being consistent, the planning board did make a determination. BMCCC should be the zoning for this property. Did it know? Did we know? No. And would that recommendation been different? I don't know. I'm going to guess no. It would not have been any different as far as that recommendation. Now we're moving forward with these two alternative processes, which has taken a lot of time and energy. And we hope to get to a point where the property is zoned. And then we'll revisit the issue that's not before you of is this an appropriate use or not. It's a question of has there been a change or mistake? Certainly the neighborhood has changed. The actual property itself, it's not a property, one property over adjoining. It's not a property, two properties over, or three. It's the actual property, just not what was considered in the four corners of what property zoned and was an issue in CCMP.
Mr. Array?
Sir, but during the CZMP, even though you do not disclose the intended use, during the zoning, there are people that we receive from different communities coming to testify that we don't want this change from this to this. So do you have a problem, getting permission or support from the businesses around?
Well, I may have
What
a,
you're talking about is called spot zoning. You can't say I'm going to do this.
No, that's not what I'm saying.
Rezone it to it. No, that's absolutely what it is. If we say something, I've seen people say, I'm going to do this, and if they don't do it, they do something different. So it'd be silly if you represent you are going to do something, and then you're not bound to it because you can't say I'm tied to that use. I'm being very transparent. We want the BMCCC zoning, not getting into the.
We understand that, but can you get something in writing in support from, for that change from the businesses around?
So again, going to the CZMP, I met with the community directly behind where this is. I met with them. I know the councilman followed up with them. I was satisfied they were okay with where we were. I asked for something in writing. They didn't give it to me. I could ask again.
Yes.
And then all I could, they're not going to give it to me.
Well, you don't know that. You don't know that. If you can try to get support.
can we also maybe possibly see, do you guys have records of all support or complaints for each issue from CZMP from last winter? Can we see if there's any of that? Good or negative or positive? That might be a good start. Because we all know people that have issues, people that, I don't.
You guys have a recording?
People always have, we know people who have the negative opinions, have no problem voicing them.
We have recordings, we have paper files, there's some written comments in the paper file we can share with you. But I also remind the body that this parcel at issue today was not before the public. It was the other parcels that were included in the actual zoning map request before the planning board that did not include the piece of property that is now being requested for rezoning. But yes, Ms. Pinheiro, we have those comments and we can share those with you.
And respectfully, this is an error or a change or mistake. If this is part of the same property, even though it wasn't considered, and it's adjoining property, which it is, it's owned by the same person, that can still constitute a change in the neighborhood. It is not, as Mr. Lafferty represented, something has to be built. I beg you to produce a case that the courts have come up with as far as precedent that is the standard. Something has to be built. If not, if something gets zoned
sometimes it is a use change, sometimes it's just a zoning change. That is the standard, come up with that case law, we can.
And we can
have a
debate that
full
all day,
hearing and brief
Mr.
it as well.
Luke. If Mr. Ventori can come up with case law to show it just the opposite.
I think going back to what the director just said, that particular piece was not a part of public discussions during the CCMP. Can you then, I'm going to go back to what I said. I hear hesitation in your voice. Can you then go back for that particular piece to get support from the neighbors? You heard what he just said. He said it was not a part of it. Now that we want to make it a part of it, can you then go to the neighbors and say, this is what we want this change for this particular piece? Is that what to do?
I absolutely go and talk to people.
Thank you. Thank you, sir.
Additional question, Mr. Chairman?
I guess my concern, and I think it's really important, Steve, that we see the copies of the testimony, because I think we had a process that we took really seriously when particularly if we voted counter to the recommendation of the department. And you're right, Mark. I mean, I took a lot of notes and I used those notes when I voted yay or nay. And we don't have that. And to go back and talk to folks now, who would those folks be? I mean, you can pick and choose positive folks or negative folks, I think. Is it the homeowners association, the improvement association? I don't know. But I don't think we can make any decision until we see that testimony.
Yeah.
No, it's not a question. I'm making really comments for the board.
Yes, Ms. German, we will get you as much as we can on the public testimony. I have, like I said, written notes, but we can probably go back to the recordings and see what we can pull out for you as well.
Thank you.
There were also a number of letters submitted too, and I don't know if that.
Yes, we have, those are in the folder that we can provide.
Yeah.
Any other questions, comments for any of the participants? Slowly.
I just have a comment really quick. We had a property like this in our area, and the neighborhood association letters went a long way in changing it. It took a long time, but I think it did tip the scale a little bit. I don't know if you guys, I wasn't on the board, so it wasn't up to me, but I think it went a long way. He came out, he explained everything about the property, what could happen, what couldn't happen. And that's actually how I learned a lot about this process. So it did kind of go along. I agree with you. It did go a long way, I think, in just getting the surrounding communities on board. It's just a comment.
Any other comments, questions? If not, thank you. We will now call upon those who have completed the sign-in sheet located in the Jefferson Building lobby to speak on this topic. Are there any speakers?
There are no speakers.
I'm shocked. Are there any further comments or questions?
I mean, it was posted, right?
Oh, yeah.
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 It was posted recently. This hearing was not posted.
This was not posted.
I got you.
It's advertised as all the other planning board meetings are. And 2 newspapers of record as well, as required.
So if there are no further comments or questions, are there any further comments or questions? This concludes our public hearing. The planning board is scheduled to vote on this matter at the July 17th, 2025 board meeting. Do I have a motion to adjourn? Motion. Second. All in favor? Aye. Thank you very much. So our next meeting is July 17th.
Guys, don't forget, it's Tuesday, not Thursday. Tomorrow is not Friday. We never meet on a Tuesday. Today is